Well, good morning, everybody. For those of you who may not know me, my name is Tom Hubric, and I'm the president of Hubric Resources, and we are absolutely delighted to have you all on the call here today. We have about 66 attendees, which is a record for us. So clearly, this is a topic that everyone is interested in. And as you may know, things are changing by the day. Today's presentation is really meant to be informal, really just to bring awareness to the topic and how it's impacting employers. So as we know, in some cases, things are changing by the hour. So certainly buckle up. We're living in interesting times. So in terms of our presenters today, I'm delighted that we have Doreen Kutzler. Doreen is a senior consultant with Hubric Resources. Doreen's been with us for about 5 years, but I've worked with and for Doreen. She was actually I was a client of hers at one, or she was a client of mine at one time. So, but she's been, we've known each other for about 17 years and is a great member of our team. And also delighted to have Susanna Fulton, who is an attorney with Barley Snyder. She's a labor attorney, and she's practiced law for over a decade. And our firm has partnered with Barley Snyder on some things over the past few years, and highly recommend Barley Snyder. It's a great firm, and we're delighted to be able to have Susanna with us here today. So a few housekeeping items. Please make sure that you keep your computer muted. We will be answering questions at the end. So if you do have questions, please put those in the text box and we will answer those. We can't do any live questions today just due to timing because we're only here for an hour. If we do run over, and we expect that we will, when we get to the questions, we will stay on the call after 10 o'clock for a little bit. So if you do have questions, please get them in the text box and we will get those answered for you. But in full disclosure, I must tell you that there's going to be some cases where we're not going to know the answers because things are changing so rapidly. So we're going to do our best to answer your questions with the information that we have in front of us. And then next slide. Also, this is just the standard disclaimer that, of course, we have to give, that we're not giving legal advice. We're not representing anybody. This is just meant to be general guidance. And for goodness sakes, we are not taking a political stance on anything here. So we have worked very hard to make sure that we're not doing that. So at this point, I'm going to kick it over to Doreen, who's going to get us started.
Great. Thank you, Tom, and good morning, everyone. So for the objectives this morning, we'll provide an overview of key changes that will impact employers under the new Trump administration. Susanna will certainly provide a legal overview. I'll provide an HR overview. We have some polling results along with Q&A towards the end of the presentation. So today's topics, we'll talk about immigration policy shifts, I-9 forms and e-verification expansion, the NLRB, National Labor Relations Board and union policies, non-compete agreements, some wage and hour updates, the rollback of DEI, agency budget cuts, and finally, EEOC and workplace discrimination changes. Thank you to everyone who responded to our polling survey questions. First one is, how familiar are you with the new executive orders being introduced under the current administration? The majority of you are somewhat familiar. And again, as Tom mentioned, with it changing practically on a daily basis, it's easy to understand. 5% or more very familiar, and then 22% not familiar at all. A second polling question, of the following new employment policies, which do you think could impact your business the most? Based upon the responses, certainly wage and hour at the top of the list, coming in at a little over 21%. I-9 forms and the E-Verify expansion at 16%. EEOC and workplace discrimination at little more than 13%, and then tied for fourth, agency budget cuts and rollback of DEI. So what does this tell us? Most employers will realize an impact as a result of the changes. So moving into our first topic with immigration policy shifts, Susanna will provide a legal overview.
All right, good morning, everyone. Thank you for joining us. So the first thing I'm going to talk about is what legal changes we've seen in terms of immigration under the new administration. So we've seen a lot of executive orders coming out related to immigration, and President Trump has directed the Department of Homeland Security to be far more aggressive in deportation practices and other things we're going to talk about. So first off is one is that there's a temporary suspension of refugee admissions into the United States at the southern border. And the Department of Homeland Security has decided that they are not going to review these new applications unless the department advises otherwise for the time being. They're ending the catch and release practices. So it used to be if an undocumented immigrant was, found to be here in the U.S., they would catch the person, but then release them while their immigration case was pending, and that's no longer the case, even if that person happens to also be an asylum seeker. They'll be doing a lot more fast-track deportations and expedited removals, which means that people can be deported now without a court hearing to the extent permitted under federal law. And the Secretary of State, Attorney General, and Department of Homeland Security are limiting humanitarian parole and designations of TPS, which is temporary protected status. And that temporary protective status is important for employment authorization. So right now, we're expecting that temporary protected status and employment authorization documents based on that protected status are likely not to be extended for people who already have it, and probably won't be granted for people who are newly arrived here. We also expect that there could be workplace raids by ICE coming in and asking to look at people's papers to see if any workers are undocumented or if they're legally authorized to work. So people should personally have their papers available, and businesses should also have their papers available in case they were to be raided at some point. We're also seeing enhanced and increased work permit scrutiny. The Department of Homeland Security is trying to work even harder to ensure that work permits are not given to people who don't have any type of legal status, even if they have a pending immigration application. And this change is going to really radically restrict the population of people who are eligible to work in the United States legally. That we expect a lot more audits of federal contracts and who contractors are hiring. There's going to be enhanced vetting for visa applicants and people who are already in the country. So this means that if you're trying to hire somebody from outside the country and sponsor them with a visa, as employers sometimes do, there's a higher likelihood that any U.S. consulates or embassies are going to put these visas kind of in limbo and administrative processing, so to speak. And we also are predicting that there's going to be a lot more scrutiny of people who are trying to get visas from so-called high-risk countries. And that there'll be more delays in issuing visas, and there might be more processing required and with additional security clearances. All right, next slide.
Okay, so with these immigration policy shifts, we'll likely see stricter enforcement of items such as chain migration, where immigrants legally residing here in the country may previously sponsor members of their family to join them. So it occurs through a family-based immigration policies. So spouses, children, parents, sometimes siblings can obtain visas or green cards. Also, with workplace immigration enforcement, ICE has been increasing raids in multiple cities with multiple arrests through January and February. When you think about limitations on asylum and refugee programs, there are 3 employers with high potential of impact: the agricultural and food processing industry, healthcare, hospitality and service industries. With agricultural and food processing, many refugees and asylum seekers work in farming, meat packing, food processing. So restrictions in these programs could exacerbate existing labor shortages. In the field of healthcare, refugees and asylees often fill critical roles in healthcare, like home health aides, nursing assistants, caregivers. Limitations will make it harder to staff those essential services. And in the hospitality and service industry, hotels, restaurants, janitorial services rely heavily on immigrant labor. Those workforce gaps in these areas could lead to increased labor costs and service disruptions. So, Tom, any comments or anything to add regarding immigration policy shifts?
Sorry about that. Yeah, you guys did a great job of covering it, but I would say this, we do have some clients that have staff that are on immigration visas and they rely very heavily on those positions. So I am a bit concerned, just want to get this on folks' radar screen that if we do get more strict with them or even consider deporting people, that could have a real impact on the labor market. Also, we do have an issue where there are some employers that tend to pay a little bit more that or pay a little bit less than kind of the prevailing wages with immigrants because they can get away with it. I'm not saying it's right, but they're doing it. But with that said, that could really have an impact on budgets if this gets tightened up. So I'm just fearful that folks are going to be paying the labor costs are going to continue to go up, at least in the short run as a result of the changes. Next slide.
Okay, thank you.
Okay, so kind of going hand in hand with that, it's really, really important, and Doreen will talk about this too, that we anticipate I-9 enforcement, that form that everybody has to fill out when they start employment. So during the first Trump administration, I-9 audits more than quadrupled. And under that administration, there were over $121 million in judicial fines, forfeitures, and restitutions issued from like 2017 through 2019. And during the Biden administration, they kind of de-emphasized this a lot. So we're expecting now under the Trump administration, they're going to ramp back up and be highly active in terms of, enforcing the I-9s. And we'll talk about E-Verify too. So what we're expecting could happen are, again, could be audits, there could be raids. Audits are when Department of Homeland Security or ICE comes in and they ask you, to review all your forms, which you need to have ready to go and available and make sure that they're done correctly because they are searching for undocumented employees. And if you have those and they find them, you can be facing really, really high fines, up to almost $30,000 per person if it's a knowing violation, if you knowingly hired somebody who isn't authorized to work. And then in comparison to raid is when ICE actually, shows up, is knocking on your door, is coming in with usually without warning at your work site, disrupting everything, which can be a mess. So that's why it's really important that we have our I-9s properly filled out with the proper documentation. As far as E-Verify, right, we already know that that's required in Pennsylvania for employers in the construction industry or people, Pennsylvania employers who hold public contracts. There have been efforts within Congress in the last few years to mandate E-Verify nationally across all 50 states. That hasn't happened yet, but we are predicting that with this push with the I-9 enforcement, that new immigration policies, that this could be something that could realistically happen, that every employer would be kind of phased in and being required to use the E-Verify program in order to determine that people are legally able to work in the United States. Okay, next slide.
With the heightened workplace enforcement, you can expect, as Susanna mentioned, more frequent audits and investigations with increased legal and administrative costs. So companies will want to invest in internal compliance programs to verify employment eligibility and avoid costly penalties. And with businesses that may either knowingly or unknowingly employ undocumented workers, they could face fines in the millions or even criminal liability for executives. I'm aware from a colleague, actually one of our consultants, that there was an ICE raid at a local apartment complex where they were literally going door to door and knocking on those doors to determine whether or not there were any illegal immigrants residing in that community. So it's going to be interesting. Tom, anything to add?
Yeah, thanks, Doreen. So just a couple things on this subject. I will say this, when we come into a new client, I can tell you that in almost all cases, probably 98% of the time, folks don't have their I-9 forms completed properly, or they don't have them, or they're not done properly. So please make sure, I would encourage you that now would be a very good time to do an I-9 audit to make sure that your I-9s are completed properly and you're all set in that area. Also, please make sure that you are not accepting photocopies of documents, that you are looking at the originals. We had a client last year that we discovered that they had over 50 employees that were not legal to work in the United States because they were accepting photocopies of documents. So please just make sure that your I-9s are buttoned up and you're accepting only the original documents when you're verifying. Next slide.
Okay, this is a area that has seen dramatic and very fast change. The National Labor Relations Board, and a lot of people have the misconception that if your workforce is not union, that this law, the National Labor Relations Act, does not apply to you. That is not true. It applies to all employees, except for supervisory employees. So this means that even if your workforce is non-union, your employees still have rights under this act. And one of the first things that Trump did when he took office was he fired the general counsel for the National Labor Relations Board. And the prior general counsel was extremely pro-union and issued a ton of what she called guidance memos so that the investigators on the board were very aggressively pursuing companies for things like handbook language and non-compete and severance agreements. So now that she is gone, we expect less aggressive enforcement. But the other wrinkle in this is that the board typically has 5 people on the board. And when Trump took office, there were 3, which was fine. That's enough for a quorum. That's enough for them to make decisions on cases that come before the board. President Trump fired a member of the board who still had time left on their appointment, which is pretty unprecedented. But that means that now there's only 2 people on the board, and without that quorum, they're effectively paralyzed. They cannot hear cases. They cannot make decisions. Obviously, we expect somebody new to be appointed because we expect a new board that would be more pro-employer to start overturning decisions that were made under the Biden administration. So we're thinking that they're going to be looking to overturn things with how, unions could be recognized. There were a bunch of decisions that came out within the last couple of years that were very pro-union, especially in terms of, if you're separating someone from employment and you're having them sign a severance agreement. According to the general counsel of the board in a recent decision from a few years ago, you're not allowed to have confidentiality language in that. So we expect things like that to likely be overturned once there are more people on the board. The board can still do day-to-day things. They still have investigators. So if somebody were to file an unfair labor practice against your company, it would still be investigated by an investigator. We don't know how many are left, and we're going to kind of talk about, agency and employee cuts that have been going on. So that will likely really slow down and handicap a lot of these agencies. But as for now, the board itself cannot hear cases, but we still expect investigations by the investigators in the different field offices to keep going. But we think there'll be a lot less aggressive enforcement of pro-employee policies. So this shift has actually been, in my opinion, beneficial to employers at this point. Next slide.
So with the NLRB, the union policies, that you'll expect to see pro-business shifts in labor law enforcement. You may see it ease up with compliance burdens for employers, but require careful workforce management to maintain positive employee relations. Unionization efforts could face new roadblocks, but businesses should still prioritize employee engagement and fair workplace practices to minimize the risk of organizing efforts. And then joint employer liability restrictions will benefit franchisors and contractors, but companies should maintain ethical labor standards to protect their brand and avoid any negative publicity. Tom, anything to add regarding the NLRB?
Yeah, just real quick. We have definitely seen a lot of union salting going on, especially in the trades, at least in the local Berks County, Pennsylvania area, but also with some of our other clients outside the area. So I would encourage you, as you should be always doing, make sure you're checking references and backgrounds on folks, just to make sure you know who you're going to get. Because we've definitely seen some, that's been happening a lot over the past, I'm going to say, year. Next slide.
Okay. So as we move into non-compete agreements, we did have a polling question, so thank you again for your responses. 2/3 of the companies that responded do not enforce their non-compete agreements. And then it's split for those that do and those that aren't sure. So we're going to see changes with the executive orders that have been signed. And Susanna, take it away.
All right, so remember I just talked about how the National Labor Relations Board had their old general counsel was pro-employer, and she actually had memos that came right out and said any non-compete agreements violate the National Labor Relations Act. So we expect that to go away. And then just generally, I know you guys probably remember from last year, the FTC under the Biden administration issued a rule banning all non-competes in all 50 states. And that ban was halted basically by an injunction by a federal court nationwide saying that people are allowed to use non-competes now. And we expect under the Trump administration that they will not pursue fighting that injunction. If we believe if Harris had won, then that would have been pursued to try to overturn that injunction and have the rule still be in place. But with Trump in power, we're thinking that that's not going to happen. So non-competes right now are still generally legal depending on which state you're in, right? So it's really important that if you have employees in different states, you know what's going on, right? In Pennsylvania, most non-competes are legal based on as long as they're not too long in temporal scope or geographic scope. And of course, there was the new legislation within the last year in Pennsylvania regarding healthcare practitioners. And so it's very important, again, like I said, if you have employees with non-competes in other states, it's very important that you know what the laws are there. Some states completely restrict them altogether, like California. And then other states allow them for exempt employees, but not non-exempt employees, or they have carve-outs for different professions. So just remember that that's important to know. But overall, right now, the status quo is that it's state by state at this point in time. So you need to follow whatever the particular statutes are, or the case law, whatever state that you're trying to enforce a non-compete at. Next slide.
Yes, and with those non-compete agreements, certainly, as Susanna mentioned, the uncertainty of the federal level bans on those non-competes remains unanswered. And there's potentially a return to more employer-friendly stance, allowing those employers to enforce their non-compete clauses, although, again, 2/3 of our survey respondents don't even enforce their non-compete agreements. So it'll be interesting, and especially with a state-by-state approach where some states will continue restricting their use and others remain lenient. Tom, anything to add?
I think you guys nailed it. Next slide.
Okay, wage and hours, Susanna.
All right, so a couple of the things that we've seen happen kind of started in motion during the Biden administration was, I think a lot of us were aware and concerned about the Fair Labor Standards Act salary threshold rule that raised the salary threshold for exempt employees back in July of last year, and then it was supposed to take effect the next year in January of this year, but that rule was nullified and revoked by a district court in Texas. So that means that the salary threshold increases went away completely, even the July one. And again, we do not expect the Trump administration to fight against this injunction, which means that the injunction will likely stand. So for now, the salary threshold have gone back to what they originally were at this point in time. We also don't expect there to be any federal minimum wage increase. It's also unlikely to happen in Pennsylvania as well. The big thing that's happening with tipping rules was late last year, another federal court said that the FLSA tipping regulations for the 80-20 guidance, meaning, if you have tipped employees, the percentage of time they spend on tip producing or non-tip producing work depends on whether you can take a tip credit as the employer under federal law. And again, Pennsylvania has its own laws about tip pooling and tip credits as well. So you need to be aware the federal regulations, and then whichever state your employees are, if they're tipped, you have to make sure you follow that as well. President Trump has made claims that he would like to remove taxing tips or overtime. In my opinion, that's unlikely to happen just because it's projected that if we stop taxing tips, it would cost the government $106 billion over the next 10 years. So that's a lot of money to make up to pay into Social Security and things like that. We're kind of going to wait and see what happens on that as well. And the last thing I want to talk about is the independent contractor test. And the Department of Labor, we expect them to drop their defense. There was a 2024 rule that was issued under the Biden administration, which rescinded Trump's rule through the DOL from his first term. So this is kind of like a ping pong match. This happens with every change in administration. So what we think is going to happen is that the 2021 independent contractor rule that was first made during Trump's first term is going to be brought back, which has the 5-factor test to determine if somebody is an employee or an independent contractor. And the 2 core factors there would be the nature and degree of the worker's control over their work and the worker's opportunity for profit and loss. So again, we're kind of going to wait and see what happens with this independent contractor test. But in the meantime, it's very important. I'm sure Doreen will tell you that you have to make sure you're classifying people correctly. All right, next slide.
Yeah, so with no federal minimum wage increase, Pennsylvania will be keeping it at $7.25 per hour. You can expect continued reliance on states to set their own minimum wages, leading to disparities. One key business impact to keep in mind is under Governor Shapiro's proposed Pennsylvania budget that the minimum wage will increase to $15 an hour for non-tipped employees and $9 an hour for those tipped employees. If passed, it would go into effect January 1 of 2026. As Susanna mentioned, changes to the tip credit system could potentially be a return to a more employer-friendly tip credit system, which may help businesses lower some labor costs, but the employer must ensure compliance with tracking tips and state-specific regulations to avoid wage disputes. With the exemption classification flexibility, the employers again may gain greater leeway in classifying workers as exempt from overtime. But again, your HR professionals within your organization should conduct regular job audits to avoid any misclassification risks and potential legal challenges. With a reduced wage and hour enforcement, while the federal enforcement may decline, state agencies and private lawsuits remain a risk. HR should continue their proactive compliance with wage and hour laws to prevent any legal exposure and to also continue maintaining those fair labor practices. Tom, anything to add?
Just a couple quick things. So 2 areas that we see our clients often stub their toe on is with independent contractors. And you should definitely make sure you're looking at your independent contractors and asking yourselves whether they truly can be. Typically, if it looks like a duck and it walks like a duck, it's a duck. But we do see a lot of our clients continue to have people classified as independent contractors, so you might want to be cautious with that. And then also just with the exemption status as well. We all the time find that folks have people classified as exempt when they really should be hourly. We see there's a lot of like administrative positions and things like that. So I know we're talking about hopefully relaxing some of those regulations for employers, but still be cognizant of it because we do see a lot of that, and it can really be painful if you get an audit because you're talking about back wages that can go back 2 years, as well as potential penalties as well. So Just want to keep that on your radar screen. Next slide.
Thank you.
Okay, this is a topic that has probably seen a lot of activity in the news that you've probably heard about. So since taking office, President Trump has issued numerous executive orders about that are aimed at dismantling DEI across the federal government. And there have also been some orders that are trying to target DEI programs in private sectors. So some of these were, one of the executive orders rescinded affirmative action and non-discrimination requirements for federal contractors, and trying to make them certify that they are not operating any quote unquote illegal DEI programs. The order does not define what illegal means, but I'll kind of talk about that a little bit later. There are also executive orders regarding male and female identity, gender identity, the use of pronouns in federal workplaces. There have been another executive order was to end radical wasteful governments, called to end radical and wasteful government DEI programs and preferencing. And in terms of private employers, what we've seen is the new U.S. Attorney General, Pam Bondi, issued a memorandum back at the beginning of this month saying that she was going to start targeting private companies to investigate, eliminate, and penalize companies if they were utilizing illegal DEI programs, but again, not coming forward and really saying what illegal means to them. But they're looking at, they were potentially going to identify 9 potential civil compliance investigations of publicly traded corporations, large nonprofit corporations or associations, foundations with assets of $500 million or more, state, local bar and medical associations, and institutions of higher education with endowments of over $1 billion. So at that point in time, right, they're looking for really big fish here, but it's still important for everybody to be aware of what the DEI rollbacks really mean. So again, in terms of what do they mean when they say it's illegal? We're looking at things like, we assume that they're going to be looking at things such as if there's preferences or any type of affirmative action based on race, gender, or any other protected characteristic. So if you were to have training for your employees, but only certain types of employees based on protected characteristics are made to undergo this training, they would probably consider that to be an illegal form of DEI. But, and here's the thing that shows how quickly everything's changing. Just 5 days ago, a federal court in Maryland issued an injunction against these a lot of the DEI orders, specifically saying that they exceeded President Trump's authority, violating the First and Fifth Amendments of the Constitution. So right now there's a preliminary injunction in place. We assume the Trump administration will fight this. So what it means for now for employers is, you know, you need to take a look at whatever DEI programs or policies you have as a private employer, and just kind of audit them and make sure that they're not what could be considered illegal under this new, again, there's really not a definition that's been given, but the Office of Personnel Management did issue a memo with their take on what would make a DEI initiative unlawful. And they say it's an action motivated in whole or in part by protected characteristics. And other types of illegal programs would be if you say tie a supervisor's bonus or tie a compensation or performance review to achieving DEI objectives or goals, or to, again, have targeted programs just based for certain people based on race, gender, other protected characteristics, or having programs that are only open to specific races or genders. So that's kind of, like I said, if this seems like a mess to you, it kind of is right now. And again, it's in flux, right? So we have all these orders, we have challenges to these orders, and this is likely to kind of, again, ping pong back and forth between the courts and the Trump administration. So it's important to kind of stay aware and up to date on what's going on, so you know what your company has to do if you want to continue these DEI programs and how to go forward with that. Okay, next slide.
Okay. Yeah, with the rollback of DEI, the ruling, including the nationwide injunction, underscores the importance of clarity and consistency in your DEI initiatives while ensuring compliance with the evolving legal standards. Some key takeaways for HR and you as leaders is under protected speech. The court found that the enforcement threat provision unlawfully restricted First Amendment rights, reaffirming the ability to discuss DEI topics without fear of reprisal. With contractor certification, that certification requirement for federal contractors was also blocked, removing immediate concerns regarding compliance with undefined standards. And with investigation provisions, while the investigative aspects of the executive order wasn't blocked, it remains critical to align all programs with existing anti-discrimination laws. So moving forward, we encourage you to conduct a thorough review of current DEI-related training, your communications, the contracts, to ensure alignment with both federal guidelines and your organizational values. Tom, I think you have some more to add regarding this topic.
Yeah, I mean, if all of your heads are spinning right now, they should be, because mine certainly is. And I think this really just places employers in a very precarious place, right? I mean, you're kind of damned if you do, you're damned if you don't. So, stay tuned. I think I know with our firm, I'm just still kind of doing a wait and see a little bit on this, but still starting to look at our policies as well as our trainings, because we do a lot of trainings for our clients as well. Also, just real quick, some folks came in a little bit late. And for those of you who came in late, we're going to have plenty of time at the end for questions. The only thing that we ask is that you post your questions in the text box, and we will get to your questions at the end. Next slide.
Okay. And another polling question is, what has your organization, or what steps has your organization taken to adapt to the recent changes in employment practices? You can see the vast majority haven't made any changes yet, but with some progress for folks that are in the process of adapting. And certainly with today's presentation, hopefully you obtain some further clarification and guidance, if nothing else. And a small percentage haven't made any changes, simply because they don't know where to begin. And again, it's a very fluid situation. So changes as recently as 5 days ago, more to come, more changes. And Tom's approach, I think, is probably pretty key in having a wait and see attitude.
Okay, so if the DEI stuff made your head spin too, I think a lot of the federal agencies that companies might interact with, this is going to make your head spin as well. I think we've all seen in the news that there have been massive layoffs of federal employees at various federal agencies. And some federal agencies we expect the Trump administration to kind of try to do away with altogether. We know recently that the Consumer Financial Protection Bureau has been told to stop operating. We're expecting, even if agencies aren't closed, they're going to be severely understaffed. So that would mean that if you need to submit documentation or an investigation from any of these various federal agencies, we expect wait times to be a lot longer, and they weren't fast to begin with. So we're going to have to be very patient here while we wait and see how the dust settles. With having a lot less investigators, like, for example, less FDA inspectors, if your company produces food products or drugs. We expect the CDC, right, to not have as many people, not to issue as much guidance in terms of, if there were to be another pandemic or things like that. We know that the Trump administration is targeting some OSHA policies that we expect to see, like that. For example, in 2024, just last year in April, OSHA published a new walk-around rule, which is when, if OSHA is coming to inspect your workplace, usually based upon an employee complaint about a safety issue, the rule allowed the employee to bring kind of a third person, bring a friend on the walk-around. And the problem there for employers was that an employee in a non-union workplace could technically bring in a union official as their third person to do the walk around, which would increase risk of unionization. So we're expecting the Trump administration to try to target and roll back that walk around rule. They've also indicated that they'll be targeting OSHA's heat safety rule, That came out in July of last year. And that applies to indoor and outdoor work sites, which impose really tough exacting obligations on employers when employees are exposed to temperatures of 80 degrees for more than 15 minutes in any 60-minute period. And as we all know, like if your employees are working outside in the summer, that's pretty tricky to do that. Or if they're inside, like around industrial equipment or things like that, temperature could be an issue as well. So we expect that to be a target of rollback as well. So just generally, again, we're expecting longer wait times from agencies, especially like the IRS, even if we go to file taxes for your business or corporation or even individually, we're expecting things to be a lot more slow and a lot less enforcement, again, from a lot of the various agencies, including OSHA, Department of Labor, so that's what we expect over the horizon, just so you're aware that, just be prepared. Next slide.
Yeah, with those agency budget cuts and federal funding freeze, the reduced funding could delay contracts, government contracts, grants, regulatory enforcement that potentially will affect businesses that rely on that federal funding or work with those government agencies. So organizations should be prepared for potential financial constraints, reassess budgeting priorities, and monitor legislative develops for those funding changes. With the workforce reductions in a number of agencies, a smaller government workforce will likely lead to slower processing times, as Susanna just mentioned. Your regulations will be delayed, your permits will be delayed, audits will be delayed, and that impacts industries like healthcare, manufacturing, and even infrastructure. So again, employers should be prepared for potential delays in those federal approvals. Potentially, you could explore automation or efficiency strategies to offset those slower government response times. And then with agency-specific budget cuts, businesses in government contracting, research, compliance, heavy industries, and federally regulated sectors will see that reduced oversight, reduced funding opportunities, and operational impacts. So organizations should monitor the agency funding priorities, adjust your business strategies accordingly, and advocate for continued support in critical areas. With that impact on workplace safety, certainly, those walk-through inspections or on-site OSHA audits, we'll see a reduction in those as well. Tom, anything to add?
I mean, I think the key takeaway here is, plan as much in advance as you can, because it seems like there's going to be delays. There likely will be delays in a lot of things, right? Probably including your personal income tax return, right? So you probably want to file early if you're expecting a return, and hopefully if you have to pay, maybe they'll delay that too. So I don't know. Anyways, next slide.
Okay, Susanna.
Okay, the Equal Employment Opportunity Commission, workplace discrimination. So the EEOC, I'm sure a lot of you are aware, is the federal agency that is responsible for enforcing things like Title VII, the Americans with Disabilities Act, Age Discrimination Act, all of those things. And they're usually the first point of contact when a disgruntled employee goes and files a charge against you as the employer. So there's been a lot of shakeup to the agency that we're going to talk about, so you know what to expect. So obviously, President Trump fired the general counsel for the EEOC. That is not a surprise. The surprise was that he fired 2 commissioners who still had time left on their commissions, which has not been done before. And then he has named a new acting chair of the EEOC, and that particular woman has been an extremely vocal critic of DEI initiatives. So we're assuming that now that she's in charge of the EEOC, she's probably going to lead this agency in a way that aligns with Trump's executive orders about DEI. And she released a statement saying she's looking forward to restoring even-handed enforcement of employment law and civil rights for all Americans. One of her top priorities is rooting out unlawful DEI motivated race and sex discrimination. And she has also mentioned that she has plans to roll back transgender rights. So we will talk about that a little bit more because I know people, I get a lot of questions about that from my clients. So again, we think we're going to see a lot more discrimination claims focused on reverse discrimination or cases brought by people who are trying to claim that they have been forced into some kind of illegal DEI scheme or something of that nature. We've seen that the EEOC, they issue guidance, which is basically their interpretation of federal laws and what they mean. And this guidance is issued on their website for employers. There's a ton of it. A lot of it's still there, but what's missing now since Trump became president is they have scrubbed all references from the website relating to transgender and gender identity. Now, the guidance is gone, and the EEOC has actually stopped. So the EEOC can sue an employer as the agency. Most lawsuits are brought by the employee themselves, but sometimes the EEOC will go after the bigger fish or a particularly egregious case. So the EEOC at the time when Biden was president had at least 6 federal lawsuits against companies based on transgender, gender identity discrimination. We have seen within the last month that the EEOC has gone to the courts and say, you know, we want to drop this. We're not pursuing this case anymore. So that's a major shift in their civil rights enforcement, that they are working on dismissing at least 6 cases that they brought on behalf of workers alleging this gender identity discrimination, because now the new head of the EEOC is saying that this conflicts with President Trump's orders. But here's the tension, right? So the EEOC is scrubbing their guidance, but we still have a 2020 Supreme Court decision saying that transgender people are protected from employment discrimination. We have case law from the federal courts here in Pennsylvania's in the 3rd District. We have 3rd Circuit case law saying that where courts have found that it's still illegal to dead name somebody or not use somebody's preferred pronouns. So it's really important to know that this tension now exists with the EEOC and federal case law. Another area where we expect some changes is, I'm sure a lot of you are aware of the newer than the last 2 years, the Pregnant Workers Fairness Act. And in this act, the EEOC, right, it's a law passed by Congress, but the EEOC again issued guidance on its website about what they determined what protections should be allowed for employees. And the EEOC came out and had guidance on their website saying that people should be protected not only for things like pregnancy or undergoing fertility treatments, but that if an employee needed to seek an abortion, that would be covered under this act as well. That was subject to a lawsuit in Texas, but that reference to abortion and things like that in terms of protections under the Pregnant Workers Fairness Act has also been scrubbed from the EEOC's website. And we've also seen some employers use AI technology to kind of screen job applicants and things of that nature. And the EEOC released guidance about that within the last couple of years, saying that there are inherent risks to using AI technology, because even if you mean well as the employer, whatever the AI program is you're using could unintentionally actually not screen employees to the point where there would be an issue where employees of certain protected classes are not being put forward as vetted job candidates. And the AI program could be doing this without the employer having any input into it. And their guidance was to be really careful when you use these, because you might be unintentionally biased against certain candidates depending on which program you're using. So that guidance has also been removed from the EEOC website. So just that's something important to know, that if you use any like hiring software or HR tools that, previously we were concerned about there being a disparate impact on the types of candidates that were put through, but that guidance is now gone. So there's a lot of shakeup going on. So the EEOC, again, they still have investigators. So if an employee were to file a discrimination claim against you, it would still go to the EEOC first. It would still be investigated. It remains to be seen how many investigators will be left standing within the next couple of months. And again, with all the other agencies, we're expecting with less bodies, less employees, that we're going to have even longer case processing times. And the EEOC was not quick to begin with. I've had cases that have kind of sat in limbo for 6 months to a year. So it might be even longer than that going forward. So that's something else to keep in mind. And then one last thing I want to mention is that Trump has also established a task force to eradicate agency anti-Christian bias. And that's kind of tied to the removal of the reference to abortion, the EEOC guidance with the Pregnant Workers Fairness Act as a terms of a workplace accommodation. So that's the big shakeups we're seeing. But overall, generally, the main point is, there still is case law out there that still protects, the groups of people that, are kind of being targeted by some of the DEI orders and the removal of guidance. So just have to be really careful and, seek counsel if you're confused, and there's nothing wrong with being confused. This is a confusing time that, even with the EEOC guidance changing, there's still case law out there. So it's okay to reach out for help, because this, again, is a fast changing landscape. We expect even more things to be happening, new guidance to come up, other guidance to be taken down. So again, it's kind of the Wild West out here right now. All right, next slide.
Okay. So when you think about less enforcement in the context of the EEOC, they'll likely reduce their investigations just based upon a lack of manpower, and reduced enforcement actions due to those budget cuts or policy shifts, which are favoring to employers. The impact to you as an employer is that you'll face fewer government-led discrimination probes, but keep in mind, private lawsuits and state-level enforcement could still increase. And a consideration from an HR perspective, you should maintain strong internal anti-discrimination policies and training to prevent those workplace issues, even with a reduced federal oversight. When you think about employer-friendly interpretations, changes in the EEOC guidance and court rulings may redefine how discrimination cases are even evaluated, potentially making it harder for employees to prove those claims. The impact to you as an employer is that you'll have more flexibility in workplace policies, but should still prioritize fair treatment and avoid reputational and legal risks. Also, keep in mind that HR should stay updated on legal interpretations to ensure policies align with both federal and state anti-discrimination laws, and then a shift towards employer-friendly interpretations of anti-discrimination laws. When we talk about narrowing of legal definitions, the legal threshold for proving workplace harassment or biases may be raised, requiring stronger evidence for claims to move forward. But that impact to the employer could reduce those frivolous lawsuits, but companies still need clear policies to address real workplace issues before they escalate. Keep in mind that you should continue proactive diversity, equity, and inclusion efforts and maintain reporting mechanisms to address complaints effectively. Tom, anything to add for EEOC?
No, I think you guys covered it. Next slide.
Okay, so at this point, I'm going to turn it over to Tamara.
So hey, just real quick, Doreen, before Tamara jumps on, I just want to thank you and Susanna for all of your work here today, and putting this all together for us. We really appreciate it. I know it's a very confusing time right now. I hope that things will iron out over time so that we won't be all so confused on what the heck we should do. Again, just please stay close to us or your HR professionals regarding these changes, or your counsel, of course, in terms of what to do next. So at this point, I'm going to turn it over to Tamara, Tamara DiLoretta, who is going to facilitate questions and answers.
Thank you all for joining us for this insightful presentation today. We truly appreciate your time. Please note we'll be sharing the recording and summary notes after today's webinar, so you'll see those coming in your inbox later today. We'll now address questions from the chat. If we're unable to answer all questions due to the session or their company specific, we'll be sure to follow up with you afterward. So we have questions in the chat, and the first one is regarding I-9 compliance. We have a few long tenured employees that were hired pre-I-9 requirements. Do we need to get a form from them now?
So the U.S. Citizenship and Immigration Services has guidance about this on their website, that if you hired an employee before November 6, 1986, you generally don't need to get an I-9 form for that employee. But I would say keep in mind too, even regardless of your requirements to fill out the I-9 forms, you're still expected to, not knowingly employ somebody who doesn't have work authorization in the United States. So could you get an I-9 filled out for this person? It wouldn't hurt. It's not a bad idea, but as of right now, it's not required. That could change in the future. We don't know. But as of right now, that's still the guidance from USCIS.
Doreen, anything to add to that?
No. Well, yeah, I don't have anything at this point.
Okay.
Thanks.
Okay. And then we have another question regarding E-Verify. Some on paper pre-HIRS and some in E-Verify. Guidance to moving everyone to E-Verify. So it sounds like this individual has some in E-Verify, some in the HIRS. Should we combine them and do all E-Verify?
I think that as an employer, you would want to adopt best practices. And if E-Verify is the way that it appears things will be going, I would move everything into one system.
Okay, thank you.
I would say just for consistency sake too, living in two different systems could create an opportunity for you to miss something. So I would just go the whole way.
Those are our two questions in our chat. If anybody has any other questions, feel free to quickly type them in there. We do have 3 minutes left. Otherwise, if we don't get any, we do appreciate you being on here today.
All right. Well, I guess Doreen and Susanna, you did a great job of building the presentation so that everybody's questions were answered. So, so hey, on behalf of the Hubric team and Susanna and Barley Snyder, we appreciate your participation here today. I see Tamara holding her hand up. We would have one more question. But for those of you who want to bounce off because we are almost out of time, feel free. And otherwise, we'll keep answering questions as they come in.
So we have to follow up that question that we just answered. Guidance on moving employees who have paper I-9s to E-Verify. So can we provide some guidance from a paper copy to E-Verify?
Yeah, that would be a project that would require you to put those individuals with the paper copy in through the system. It would really, you could treat it as a special project more so than anything. I don't know, Tom, do you have any other
No,
thoughts on
unfortunately,
that?
I can't say that we've ever done that before. But I may just want to start from scratch and put them through the process.
Okay, thank you. We have one more question. How should employers prepare for wage and hour audits?
That's a really good question. If you're concerned about an audit, but just generally, like, you need to be keeping payroll records, especially for your hourly employees in terms of hours worked, overtime, breaks they've taken. That's usually the auditors show up. The Department of Labor comes because somebody complains that they either weren't paid overtime or they had deductions taken out of their check illegally. or that they've been misclassified, which again is another overtime quagmire. So the best thing you can do to prepare for an audit is to have organized records, especially where payroll is concerned. Because a lot of times when these cases go to trials, for instance, the court is trying to figure out, okay, well, what's the overtime look back, right? How much are we talking here? And a lot of times you'd be surprised. The employees, like, they just say, oh, I work 20 hours a week extra over 40 every week, but there's no records to verify that. And now the employer is trying to guess, the court's trying to guess what the liability is here. So it's extremely important. I know maybe Tom and Doreen want to add, but yeah, having records is the most important thing you can do and document everything.
Yeah,
Thank you
the
very
three main
much.
words when it comes to finding a home is location, location, location. And from an HR perspective, documentation, documentation, documentation. Always helpful in all aspects.
Yeah. And you also too, you could also do your own audit, right? And or have we can help you with that, or I'm sure Susanna and her firm could help you with that as too. Is sometimes it's better to have that done so you can avoid surprises down the line. Because I can tell you in almost all cases when a lot of times we'll step into a new client and we'll do an HR assessment for them. And that's one of the first things we look at is overtime. And in most cases, there are some areas that folks just aren't complying. All right, I see no
Yes.
other questions, and it's 10:01. So again, I'd like to thank you all so much for being part of the presentation here today. And as Tamara said, we will be getting out the summary notes and the recording of this video to you all later today. So I hope you all have a great rest of your day,
Thank
and
you.
see you later. Bye.
Bye-bye.
Bye.